Hi, this is the 100, 120 speed level, and we're going to begin some warm up with some tingle tamers. For the record, insurance trust, malice aforethought. I guess I have a brief for malice aforethought. Assumption of risk.
What was it?
The penal institution, rebutting evidence, vagueness doctrine, insurance adjuster, bilateral contract, power of attorney, imputed knowledge, declaratory judgment, paid in capital, equitable interests, community claim, leading question, religious freedom, exemplary damages, capital gain, assignable error, mechanics lien, true market value, punitive damages, substituted service, juvenile court, burden of proof, crime of violence, dilatory pleas, ecclesiastical law, further relief, passive negligence, blank endorsement, highly toxic, Miranda warning, second distress, by virtue of, collateral promise, body house, BAWDY, major fault rule, mental anguish, adversary pleading, ambulance chaser, marketable title, absolute privilege, moral certainty, mental competency, collateral mortgage, eligible offender, judgment NISI, open-end company, registered tonnage, joint tenancy, fresh pursuit, acted knowingly, mandatory provisions, nominal damages, inherent power, general demurrer, high water mark, kangaroo court, opinion evidence, military tenure, federal question, claim of liberty, mental cruelty, aid and abet, admissible evidence, actual cash value, severance pay, meets and bounds, adhesion contract, true market value, and material fact. And these are going to be some medical words from the Tangle Tamers. For the record, hemophilia, mastoid, alcoholism, laboratory, disease, nourishment, cataract, eruption, adduction, synarthrosis, anemia, histology, venosclerosis, articulate, neurologist, cerebrum, genetics, cervical, tracheostomy, nasal, occiput, polonodal, arthritis, cellulitis, vascular, inflammation, orthodontia, pericardium, vomiting, memory, abdomen, infarction, experiment, aspirin, prednisone, standardized, analgesics, symptom, hypodermic, painful, aspiration, metacarpal, sublingual, hernia, quadriceps, cardiology, periarterial, ossicle, meninges, psychosomatic, temporal, orifice, thyroid, pectoral, gingivitis, headache, encephalitis, subcutaneous, hypochondriac, phlebotomy, thermometer, sigmoid, fracture, obstetrician, epicondyle, reproductive, IV, splatter, treatment, coding, hydrochloride, patient, astigmatism, intractable, nystagmus, remission, diaphragm, prognosis, prenatal, immovable, corpuscles, tachycardia, osteoarthritis, myocardium, dermatitis, schizophrenia, ophthalmology, hypoglossal, thoracocentesis. Okay, this will be some congressional warm-up. For the record, the proponents have steadfastly refused to lay out a plan to get to balance. Take it on faith, America. It will be good for the nation. I ask the American people this question. How will you know if this amendment will be good for the nation if you do not know what cuts will be made how much each state, how much each county, how much each municipality across this land will have to absorb as a result of the cuts, how much your state taxes will rise as a result of federal cuts, what will happen to federal aid to education, what will happen to Medicare, what might happen to our ability to compete with other countries in the global marketplace, what the amendment might mean in terms of clean water, clean air, veterans' pensions, the national defense. In short, what is good for the nation cannot be determined without these critical details. To claim otherwise is simply untrue. The American people are entitled to more than a wink and a nod and an empty promise. We cannot treat the American people like children. If they want us to balance the budget, we must honestly try to do it, but we must also honestly tell them what it will take and what it will mean, radical changes in their personal lives. We owe the American people that. To do less is to betray their faith in sending us here. It is puzzling to me that after the results of this election, when the people said that they were tired of Washington politicians telling them what to do, we come right out of the box with this proposed major change in our organic law, with the proponents claiming that the people do not need details. In other words, once again, we in Washington know what is good for you, Mr. and Mrs. America. This balanced budget amendment is good for you. You do not need to know the details. Take the tonic, swallow the snake oil. Do not read the label. There is no label to read. Take our word for it. Well, if the American people let us get away with that dodge, then they have done themselves a giant disservice. If they swallow this quack medicine without being sure that it will not be toxic to the system, they surely may regret the results. If the governors and the mayors and the state legislators do not demand to know just exactly what we have in mind when we talk about balancing this budget in 7 years, then how can they have an informed debate if and when the matter rests squarely on their doorsteps? How will they explain to their own constituents what the amendment means? If I were a governor contemplating the enactment of this amendment, I would be very nervous about any promises that I had made to lower taxes. I know that I have heard some of the governors throughout the land boast about how much they have cut taxes in the states. They want the Senate to adopt this balanced budget amendment, and they talk about how much they, the governors, have cut taxes in their states. I heard the governor from New Jersey speak about how many taxes she had cut and how much more in taxes she proposes to cut. Well, I have news for you, Governor. If this amendment is adopted, you will not be cutting taxes. You will be raising taxes. With the magnitude of cuts that will have to be made to get a balanced budget by 2002, the states are going to have to pick up an awful lot of slack. Essential services will have to continue. Unemployment, dirty air, dirty water, hazardous waste, hungry children, natural disasters, all of these problems will still be with us. A balanced budget amendment will not change any of those things. State and local officials should know what we here in the Congress propose to do before they are asked to buy this pig in a giant poke. We do not even know if there is a pig in that poke. We cannot even get a squeal out of that pig. This is some jury charge practice for the record. Ladies and gentlemen of the jury, first, I think we should discuss the procedural aspects of the case. I do not believe that there is a bona fide standing on the part of Mr. Fahey and Mr. Willis to attack the confessions of Mr. Trapp and Mr. Morey. I will submit that is true because I know the court is well aware of the standing espoused in People versus Victor and other similar cases that have been mentioned. Detective Fahey was quite candid with the court. The only person that knew anything about the tape recorder or made any recommendation about it were the defendants Morey and Trapp. They indicated a desire that it not be used during the interrogation. Mr. Willis, as far as I know, based upon the evidence thus far presented, knew nothing about the tape recorder. As Mr. Fahey testified, it was necessary to crane your neck and turn almost completely around in order to see the tape recorder. I submit at this time to the court that I don't know where counsel gets the picture of 5 or 6 people hovering around Mr. Willis. There were no such implications. I can't see that from the evidence. As I recall the testimony, and I know the court has taken exhaustive notes on this, Mr. Willis was interviewed by Detective Fahey and Mr. Gilgen. The last ground raised by counsel, that is, of attempting to get or say that the court should espouse a new rule requiring tape recorders, that is not the law at this time. He hypothesizes that that is the best way to do it. I submit that it is not the best way. One of the major problems here is that you are talking to a man. You are discussing attempted murder. You are discussing what he has done. You are talking to him about things such as the following. Have you been arrested before? Have you ever done hard time before? When you were in the joint, what was the last thing that happened to you? All of these questions and more are on the tape. So as the court is well aware, and as we all know, it isn't illegal to discuss all these things in getting statements from a particular defendant, but those things are not admissible in court. Now let's go on to the real crux of this case here. The real crux of this case is obviously whether those 2 men in the back row were beaten. The question is, were they beaten? Both counsel have been practicing attorneys in this town for years. I know both of them. One is the past Deputy District Attorney of Boston. I know he has been in the office several times. I have seen him. He has worked for the Darien Department of Legal Services as well. He was also over in the Cambridge office for a while. Now getting back to the facts here, I respectfully call the court's attention to People's Exhibits 5 and 6. They are the medical reports. 2 individual and independent examiners examined both Mr. Morey and Mr. Trapp. There were no bruises. There were no cuts. There were no broken bones. There were no abrasions and lacerations. There was no internal bleeding or other noticeable injuries to either Mr. Morey or Mr. Trapp. Let's look at the conception of forced confessions within the United States. The law goes back to 2 cases. One of them involves a man named Clark, and right now the other one seems to have slipped my mind. These are 2 cases arising in the South way back in the early 50s, I believe. They are some of the first 2 cases taken to the Supreme Court of the United States. Perhaps if we were in the 50s, I would say that what counsel says makes sense, but I will submit this to you, that we have no indication whatsoever of any beating taking place. This was not presented in any way, shape, or form in the testimony of these 2 defendants. Your Honor, I would submit that the sophistication of law enforcement has certainly gotten to a point today where no police officer who is going to inflict a corporal type of punishment upon a human being in order to get him to confess is going to be stupid enough to hit him in the face. That is what they want you to believe. The hitting isn't going to be in the ribs either. There are subtler ways that can be used. The police officers don't hit anymore because the current cases talk about psychological coercion, of which there is just insufficient evidence here to believe that. The testimony we are supposed to believe from Mr. Morey is that he hardly sat down in the chair before the officers started hitting him. Now he has his wrists handcuffed behind his back, and he is being hit. There isn't one iota of testimony to show that anywhere there are any injuries on the wrists or anywhere else. I submit that we don't have the burden in this case any longer, even if we had one to begin with. There was no bearing. If the court feels that I have missed any particular point that I should address myself to, I have every confidence that you will tell me so. Thank you for your patience, Your Honor.